A California man is getting millions after taking the makers of Pam cooking spray to court. He claimed that the spray caused damage to his lungs and that the company sold defective products that led to his very serious health problems. Now, a judge said that the makers of Pam, that's Conagra, are to blame.
Joining us this morning, our chief legal analyst, Khalif Rhodes. All right, Khalif, this puts a lot of people, I think, on high alert because a lot of people have used either Pam or something similar in their kitchen, some type of aerosol cooking spray. So there's a thing out there, it's been around for decades called popcorn lung. You had other cases that stemmed from microwave popcorn factory workers back in the 2000s, vaping. I mean, you hear that term a lot. How does this case differ from some of these other popcorn lung type issues when you're looking at product liability?
It's really not different. It's just, and I say it a lot of times with cases that go before the Supreme Court, but really any case, whenever you're looking for a case to take as a plaintiff's attorney, you need good facts, you need a good judge that's going to be willing to hear the facts, and you need a scenario that is right for bringing litigation. Yeah, we're a litigious society. Folks will bring claims all the time that don't have any merits, but this one lined up with everything. Pam, in their response, says that we haven't used those hazardous materials, the two that they listed in the complaint, for a number of decades. So, right, they've already listed that as a defense. Well, what do you have on plaintiff's side? He's saying, I've been using this product since 1993. Well, that's more than a couple decades that they've talked about, which would exceed the time frame that Pam is saying they stopped using that hazardous product. I mean, but it's twofold. It's a negligent product. He's saying you've made a product that you knew was faulty, negligence, but then also negligent warning. You failed to warn us of the potential dangers. We've talked about that a number of times here where if you have a product that could potentially harm someone, you have a duty to warn for foreseeable dangers that could or you should have known about at the time. So if you knew that in 1993 or whenever you guys removed this hazard, that it was already potentially harming people in that window, there was a duty to warn. And so you've breached that duty, back to duty, breach causation and damages. And obviously if you need a double lung transplant, you got pretty significant damages.
Well, yeah, and the jury agreed with this gentleman here. Those two chemicals are diacetyl and acetyl propanol. So those are no longer in Pam cooking sprays. But when someone sees a headline like this, $25 million, they're thinking, okay, am I able to get a piece of that? But this is a very long case. So how are the cases actually successful? It takes a lot of staying power.
It does. I mean, first of all, as an attorney trying to handle these type of cases, you need an extremely large bank account. Let's start there. These are handled on a contingency basis. A client comes into you and they're not paying anything. And so you're handling depositions, interrogatories. You're going to all the courts, and it's coming out of your law firm's fee with the anticipation that, okay, if I'm successful, I'll be able to get on the back end a third or maybe 40% of that $25 million. And so, yeah, these cases take a long time. If you're at home watching this, because it wasn't a class action suit and it was a single individual bringing a claim, well, you can't get any access to that $25 million. However, if you have damages, if you're someone that fits into that scenario, if you've been using it, well past when they were still using those two chemicals, then yeah, you might fall in there, but it has to be right facts, has to be right timing, and you got to find a law firm that can handle that type of case. Every firm can't handle a complex litigation like this where it's you're alleging, these type of chemicals that cause this type of harm. You're talking about experts that come in that will have to talk about the medical damage and talk about those chemicals, talk about the products. That is something that's going to cost, hundreds of thousands, if not millions, to get to the finish line.
Well, it says that Conagra's going to appeal. What would their defense be other than, hey, we stopped using those two ingredients 20 years ago? What other defense would they have?
The defense would be that the judge got it wrong, that the standard is that we warned them and they failed to heed to the warning. The risk that they saw was foreseeable and they still, used this product anyway. In terms of the negligence aspect of them, that duty breach causation aspect, no, we did all the things that we needed to do. We removed this product and he was inside or outside of that window. The judge maybe just misread or misapplied the law, or the jury misapplied the law. That's what you're appealing. We made the same argument. They just didn't apply the facts properly. We're asking you guys to relook at this because something was misproperly done here.
All right, certainly opening up a lot of eyes this morning.
Sure.
But again, not something that you can join as a class right now. But Khalif, thank you so much.
Queen City News Plus. Just search Queen City News on your smart TV's app store.